selling thing. I'm wonderful, I'm this, I'm that, and this is what we do. But when I read Sam's, he actually gave something that was of benefit to me. And that's what really interested me. So I clicked onto it, and then I read what he had to say. And it was fantastic. And I thought, I need him to go and speak to you guys. So if you're doing social media, make sure that you do what Sam did and put something there that's really interesting and will capture their eye. And just to introduce Sam, Sam Roberts is a principal solicitor of Roberts Legal and licensed operator of Fast Track Debt Collection. Roberts Legal is a general legal practice located in Amhersttown. Sam has practiced as a solicitor in Newcastle for 11 and a half years and specialises in a range of areas that he will expand upon during his presentation. Sam and his colleagues pride themselves on providing high value and quality legal service. They take a proactive approach to helping clients, which often involves evaluating aspects of the client's businesses where risk is inherent and helping them implement measures for avoiding and minimising those risks. One of those risks, namely the inability to enforce a contract commercially, relates to the making of ineffective contracts, which complements Lloyd's talks really well. So please make welcome Sam Roberts.
Good evening, everyone. Thanks, Sue. I couldn't have said that better myself. Today I'm going to be talking about how to make effective contracts in businesses, and I think knowing that Alan Stevens spoke last week was a bit of a hard act to follow. I'm sure he all amazed you with how he reads people's faces, but unfortunately my job isn't that interesting, and most of the time what I'm doing is reading contracts. Too often the case is that there is a lack of a contract, and therefore we're trying to determine what is the terms of the contract and how to help clients deal with that situation or to avoid that situation in future. But I will try and do a bit of face reading today, just mostly will be limited to seeing whether your eyes are still open. Got to go over this side, I think. But like all good lawyers, we'll start with a short disclaimer. So what I'm talking about is general information, and it shouldn't be taken as legal advice, and obviously if you have any questions you can speak to me directly. So today we're just going to quickly cover when is a contract made, what is an effective contract versus an ineffective contract, why we want to have effective contracts, what are the terms that are in them, how do you incorporate those terms into the contract making process, and what are some of the relevant terms for your bookkeepers. So, as Lloyd touched on, a contract is made when there's offer, acceptance, in circumstances where there's an intention to create a legal relationship, and there's some sort of consideration, which can be an agreement, usually agreement to pay money or provide us goods or services. So, there's no requirement that there actually be any writing at all. And part of the problem is where there's a verbal offer and a verbal acceptance, or there's a quote and a verbal acceptance, how do we determine what those terms are? Or maybe the terms that you want to rely on aren't there at all. So terms can be express or implied. An express term is something in writing, or it can be something that's discussed specifically. And implied terms, which are another whole can of worms, which are difficult to rely on. But express terms, when we're putting together contracts, you're really looking for something in writing. If it's an email or something like that. But ideally you want it in a single set of terms and conditions at the outset. And that's mainly what I'm encouraging today, to make sure you've incorporated those terms into the contracts that you make. Including terms on an invoice is not effective in incorporating into the contract. The reason is, as I said, the contract is made when there is offer and acceptance. Invoices come after the contract's been performed, and you're almost saying, look, do you now agree to those terms? And they'll just say no. So that doesn't work unless it's already reinforcing what's already been agreed to at the outset. I mean, it's not a bad thing to have your payment terms on your invoice, provided that was something that's already been agreed. So, effective versus ineffective contracts. We want acceptance of written terms and conditions. The terms should be clear and comprehensive, so that the parties' roles, obligations and responsibilities aren't ambiguous. I've talked about here commercially enforceable. So a verbal contract is still enforceable in nearly all cases, unless it's in relation to land. But the problem is, how do I determine what the terms are, and is it commercial for me to enforce it? See, if the other party can raise an argument to say, that's not the terms that I believe I agreed to, or I dispute that, you're faced with the decision, do we run that case and therefore risk having a defended litigation situation and the costs and the delays that are associated with that, or do I not run the case, or do I make a compromise and settle for something less? So that's where your terms are commercially enforceable. If you've got clear terms and conditions, what you'll find is that they are commercially enforceable. You're having to make less commercial decisions to sacrifice your fees or your rights just to get a result. So the benefits are you're avoiding most common disputes. May not be as relevant, well, it probably would still be relevant to bookkeepers, but most disputes are about the scope of works. Make it clear what you've agreed to do. How do we calculate what we're entitled to, and how does that change? What if the scope of works changes? Is there a process for agreeing to that change of works? There's lots of disputes about the fact that variations weren't properly documented, or we didn't agree to that extra work, or we didn't think there was going to be an extra price. And what are the warranties and things that go with the works or services that you're providing? So, again, clear, effective contracts, they're enforceable, and it's commercial to enforce them. And generally, because they're enforceable, you'll find that your cash flow is improved. So that's a side benefit, I suppose, but it's an important benefit. You're not having to write off bad debts or make those commercial decisions not to pursue them because you've left yourself open. And if you're making procedures to make contracts this way, and they're effective contracts, when it comes to selling your business, and you've got a buyer looking and doing their due diligence, they're going to see that you're making effective contracts. The contracts that you've got in place are collectible, and the ones that you're working on now are also going to be enforceable. And assignment provisions are important in that context as well. So what are the terms in an effective contract? Look, there's a fair bit to cover, so I'm trying to rush through and I'm aware of time, but if you have any questions, then just jump in. Getting a privacy consent isn't so much a term of a contract as it's a precondition or pre-consent. It still allows you to make inquiries in relation to whether you want to make that contract at all. Sometimes getting a personal guarantee from someone who's too willing to give you a guarantee is something you should be concerned about. It's not rare structuring advice for all of the assets to be put in the wife's name. Certainly is in the building industry. The husband's a sole director. He's giving out personal guarantees left, right and centre. If the company goes under, he doesn't care. He'll become a bankrupt. Nothing's lost. So if people are too willing to give personal guarantees, you need to start delving into it. Getting consent to get a credit report is an important step. And even also doing searches, title searches to see what properties they own if you're going to be extending large amounts of credit. Yes. You need to have a consent. It's either built into the contracting process or in the credit application.
And just on that point, recently had a client who actually had a credit report approval given. The business went under, and the firm that had the personal guarantee walked in saying, really one concern, as I said, we know you've got equity in your house.
Yep.
Turns out the information that they were provided when they did the credit report was actually wrong. The house, the only substantial asset, was in fact fully mortgaged. So this supplier has actually worked off incorrect information that they received from the credit agency. So you can't even always rely on the credit reports yet.
Any sort of search that shows a title, there's always a risk that there's no equity in it. So there's only so many things you can do to protect yourself. I mean, getting a personal guarantee is better than having no personal guarantee. Getting a guarantee from someone with property is better than someone with no property. And also, whilst you might have got the guarantee, the bank comes in and stitches up all the security. They're a registered security holder. You're unregistered at that time. And I'll talk quickly about personal property securities as well. Making informed decisions is about getting those credit reports and not extending too much credit unless you're sort of prepared to take that risk. So moving on, Fixed terms. So this is relevant if you have a contract that relates to a fixed period of time, as opposed to just something from week to week or month to month. It's a benefit for two reasons. It gives you sort of value to your business and certainty of cash flow. You know you've got guaranteed work in place, and if someone cancels that during the term, then you may have entitlements to compensation from them. Clear payment terms, if it doesn't say that it's 14 days or 7 days or 30 days, then the answer is it's a reasonable time, whatever is a reasonable time having regard to the circumstance of that particular industry. So that's not always an easy answer. If you require deposits, you want to make sure you've got a right to deposits. Passing on GST, as you're aware, it's a tax on suppliers. There's no automatic right to pass it on to your customers. And interest, if you've got a late payer, it's good to have a right to recover interest at a healthy commercial rate. Now, whether or not you choose to enforce that is a commercial decision to you and your relationship. But if things go sour, you're not a bank. So why are you providing credit to someone without a right of interest? There's our statutory rights to interest, but the rates aren't great, and you can get obviously not something unconscionable, but a healthy commercial rate. Conditions precedent, talking to someone in here about what are the difficulties that you face in your industry, and someone mentioned about getting the right information from the client. So it's clear that if there are certain things you need to happen before you're going to start the job, and this is relating to any industry, you want to make sure there's a clear agreement of what those are. So there isn't scope for a dispute about someone saying, well, you should have done this. And we're clear, no, I didn't have to do that until these things happened, which may have included payment of certain monies. So I talked about having clear terms about what the scope of works were, but equally then what the scopes don't include. There's much disputes about that, so clear exclusions about what's not covered, which also leads into then what might become a variation if certain circumstances occur and you're asked to do that work. The right to subcontract and assign, so unless that exists, if you subcontract work or seek to assign it, you'll be in breach of the contract, so that's putting you at risk. But also, again, if you're looking to sell a business and you've got a right to assign, you can preserve that value, and it's much more attractive to someone who's looking to buy you. Rights to suspension and termination. So just because someone doesn't pay you doesn't mean you can stop work. You might find that you're in breach of the contract because you haven't continued to perform. Until the contract comes to an end, or there's a right of suspension that you've invoked, you've got to perform your part of the bargain. So having a clear understanding about when you can suspend works and how to suspend it, or how to terminate that contract if you decide to do that, then that takes or solves a few problems, namely you don't want to keep doing work and incurring or giving further credit if they're not paying, so you want the right to suspend, and you want to avoid the potential that the other party turns around and says that was an invalid suspension, you're in breach of the contract, that's an invalid termination, you're in breach of the contract. So it's just about having those terms and rights in your contracts. So I've talked about security. Well, I haven't talked about security, I've talked about personal guarantees, but security basically consists in security over real property. Okay, so the common form of security is a mortgage. We're not really talking about getting mortgages in general business contracts, but you can obtain a charge over real property and a right to register a caveat over property. So a caveat stops people dealing with property, and you can't just go and slap caveats on left, right and centre unless someone has given you an interest in the land. And you can create that in the contract, and as Lloyd pointed out, people may be reluctant to do that, but unless you put it in there, you don't have it. And what I'll emphasise is that people without those securities and without those guarantees, when the company that they're dealing with goes into liquidation, they are left with nothing. They're high and dry, and they're facing liquidation themselves. Personal property security, so you probably would have heard about the Personal Property Securities Act that came in this year. So it's changed to the regime about taking security over property. Now, if you're providing services, it probably doesn't affect you at all, but if your clients are providing goods, then it's certainly relevant to them. If they thought they had retention of title provisions, they're enforceable to some extent, but they can be lost if other people claim superior interest in those property, and that comes back to registering your interests. But you can't do any of that unless you've got a contract that creates a security agreement in relation to particular property. So you've got to get that in your terms and contracts, terms and conditions from the outset. Personal guarantees. I'm a big advocate of contracts that ask for personal guarantees for the reason that if they're not there, you're one of those people that's an unsecured credit. I mean, actually you're an unsecured creditor of the company in liquidation anyway, but now you've got another target to pursue. I have an ongoing debate when people say, well, what if they don't give personal guarantees? And I say, well, you get to have this conversation. If your contracting procedure is that there's an acceptance that comes back and there's a clear guarantor signature and it comes back unsigned, you ring them up, look, our policy is that we require guarantees. They say, well, that's great, but our policy is we don't give guarantees. Well, why is that? Don't you think you're going to be able to pay? Maybe they say, well, we're not sure or whatever. They might say, yes, we're able to pay. You might say, well, look, basically, we don't have cash flow problems because of this is one of the reasons. And if you don't give the guarantee, then we either won't supply or we require payment on other terms. Maybe it's more up front or payment in advance, or we need to increase our price to factor in the risk that's associated with that. The important part here is that you're getting information at the outset to make that decision going forward, as opposed to not asking for a guarantee and then when the problem arises, you're certainly not going to get it once the company's in financial trouble. Legal costs and enforcement costs clauses are also, if I had $1 for every time someone said to me, can I recover my legal costs of this? I certainly wouldn't be here today. So the answer is, unless the court orders them to pay your costs or you have a contract that says you can, no, you can't. If you have a contractual right to recover debt collection costs, and even if you don't have to go to court, you can pass on your lawyer's bill or your debt collector's bill and add that to the debt. So very important to have. Limitations and exemptions from liability. So again, why expose yourself to risk? There's statutory limits that you can, or certain degrees that you can limit your liability, but if it's not in your contract, it doesn't apply. So it should be there. Similarly with warranties, you may want to give certain express warranties or limitations on warranties. Again, some warranties are implied by law, but they can be limited, but only if they're in a contract. I mentioned before that a contract can basically be a combination of verbal statements that were agreed, emails, all sorts of other documents, unless you've got a term that says entire agreement. If you've got a document that says that this is the entire agreement, then all those things are gone. And you can avoid a lot of dispute where no one's saying, oh, that's also a term of the contract. Well, no, if it's not here, then it was just a pre-contractual negotiation. It wasn't important enough to be here. Otherwise, you would have brought it to our attention and put it in the contract. And similarly, that ties in with no reliance. They're saying, well, no, you've warranted to us that you didn't rely on it, and that this was, in fact, the entire agreement. So it's all about avoiding disputes. The Building Construction Industry Security of Payments Act, you probably have clients in that industry. That is my favourite piece of legislation, and it creates rights for contractors that are unlike any other rights in any other industry. Because it's so significant, and when the lawyers get involved and there's cases, there's requirements for strict compliance with that laws, and to make it easy to comply, there's certain things you can have in your contracts so that the payment claim process is more likely to be a valid process. I see people get it wrong all the time. It's not to say that in most cases you can go back and start the process again, but if people get it right from the outset, they'll be having they'll be able to derive the benefits from that legislation. So if you have any clients in the building industry, I would recommend that it's just, if they don't have contracts in place or use terms and conditions, they're putting themselves at unnecessary risk. So how to incorporate all these terms and conditions? We want all these documents to become all these terms to become part of a contract. As I mentioned, not in an invoice because the agreement was already made when you agreed to do the work or supply the goods. There needs to be disclosure prior to acceptance. Okay, and if it's going to be a page of terms and conditions or whatever, it needs to be in writing. So basically, there's four ways for express incorporation. It can be part of a single document that they've signed off. They've clearly accepted those terms and conditions. A contract for the sale of land or a commercial lease is a good example of that. Most contracts in businesses these days are either one of the second two. So if it's in a professional services area, then usually there might be some sort of engagement letter that might incorporate a set of terms and conditions or attach another contract. But both documents sort of define the scope of works and the terms and conditions. Or what you might find is that there is no terms and conditions, it's just an engagement letter. With our debt collection business, I've been speaking to, more businesses at how they make contracts. I had a local accountant, very impressed. He thought he was. He sent me through his costs agreement. Thought we'd have no problems with the collection. He had a 3 or 4 page document. When I looked at it, probably 70% was about the fact that he couldn't give accurate information for his tax returns. He could only base it on what it was given to him. The only term that related to really a contract was a clause saying that he estimated the cost was going to be this. There was not actual term about what his charge rate was, let alone any guarantees or anything like that. So when I said, really, it's very poor, he was surprised. So, really worth everyone reviewing the terms that they make or the contracts that they make. Most people in the building industry or suppliers, they'll be issuing quotations, and there needs to be disclosure of the terms and conditions at that stage, and you're almost giving them the form of purchase order or work order that needs to come, and that needs to make it absolutely clear about incorporation. So basically, the more onerous your terms and conditions, the greater the responsibility on you or the need for you to bring it to the person's attention. There's that temptation of it just slipping in there. The fine print's so small, but it has to be quite clear that these conditions apply. And when you accept, this is what the terms that you're accepting. And if that's the case, then they can be incorporated in that way, whether you're giving them terms and conditions, whether they're available on your website or all of the above. But ultimately, if you're contracting regularly with the same customer, they've got your terms and conditions before, you just keep sending them the quotations or whatever it is, and those terms keep applying. Online contracts, you probably all filled out online forms. They are binding. I don't know how many people actually read all of them. I certainly don't read them all. But certainly wary of them, and you should be wary of them. But again, the more onerous the provisions, the greater need to sort of have all those checkboxes. And even if you are having guarantees, a separate checkbox that this is where you click and the person filling this out is the guarantor. And signed acknowledgement and acceptance. So you might have your terms and conditions there, you might have sent out your quote, someone rings up and says, yeah, go ahead. That same situation, you try and enforce a guarantee later and you can't show that signed document. So what are the terms that are relevant for a bookkeeper's service contract? Well, pretty much most of the ones that I've talked about are relevant. I would have thought the scope of works and your obligations in terms of the performance of those works would be important, particularly time limitations that might exist. The term of the agreement, so I don't know whether you're on week to week constantly, but if you lock in a term, you're going to be given much more certainty about the cash flow moving forward. You can plan your business around that, plan for growth and whatnot. The method of remuneration and reviews, whether you're doing fixed fees or hourly rates, how that changes. Even if you've got someone on, it's just a week to week to week to week. Well, when do you get to review your charge rate? What method do you get to do that? If there's nothing there and you just say, well, look, it's fair that I just review my rate, they might say, well, no, I'm not happy with that. You'd say, well, I don't have to continue to do the work. That's right, and they don't have to continue on as your bookkeeper. So the fact that it's there might make that a bit smoother. And subcontracting and signing, I don't know how many of you share work and subcontract with each other, but there would be a danger that would be a breach if you didn't have a right to do that. I think I've covered suspension and termination about why it's necessary, guarantees and security for the same thing. You don't want to be that person that rings me up and says, the company's gone into liquidation, what do I do? First thing I say is, do you have a guarantee? Otherwise, all you can do is send your proof of debt to Lloyd and sit back with your fingers crossed. Legal collection costs, particularly where your invoices may not be huge amounts, and therefore you're faced with, what's the cost of enforcing this $500 bill? Is it worthwhile? If you've got one of these clauses, it's worthwhile every time. And limitation of liability. I don't want to cover that again. So what should you look out for? If clients have poor cash flow or bad debtors, they're probably not making effective contracts. And you can add value to your clients by trying to alert them to this. If they just provide verbal quotes, again, there's no opportunity to incorporate terms and conditions, or if they've quotes without terms and conditions, engagement letters without terms and conditions, or they're supplying on credit without a credit application. Even where there is a credit application, it may not be adequate, particularly with changes of the Personal Property Securities Act. So they really need to be reviewed. Thought I'd throw in a quick plug. So, as I mentioned, we've started a debt collection business this year, and it ties in with our legal practice. And Sue's got some handouts. We put together a 6-step guide to improving cash flow, which was a little hobby of mine. My website developer says, "Oh, you've got to have an ebook." I said, "All right, this will be good." And actually, wish I had have known what was in there when I first started a legal practice. Mostly, it's a common sense tips set out in there, but there's also big emphasis on making effective contracts, because if you do, you don't have to have these problems, or if you do have the problems, you'll be more likely to enforce them. And through our fast track debt collection, we actually provide a unique debt buying service. And as far as I'm aware, we're the only company that buys individual business related debts. So there's companies out there that buy, hundreds of thousands of dollars worth of debts and big debt ledgers. We actually buy individual business related debts, provided it's above $1,000 and it's still within the limitation period. Now, we don't buy every debt, and typically our range is between 5 and 10%, so we're looking at people who've given up on a debtor, and it might be that your clients are about to write off a debt, and if that's the case, what debts have they written off in the last few years that there might be something in it for them? So we buy debts from $1,000, and we're buying one for $94,000 at the moment. We're not paying that, we're paying something less, but we do look at it. So does anyone have any questions about that? I know we sort of rushed through it quite quickly, but I hope what you take from it is that if you're not making these effective contracts, then you're sort of putting yourself not in the same position as someone who is.
Questions now. One of my clients has got an account with Tabling, and we got an account, drew it up, signed off, and we've been using their supplies probably 6 months ago. And now we've got a letter saying they want to redo their terms and conditions, and we have to sign a whole new application for credit, etc. And one of the things I noticed is instead of 30 days, it's down to 14 days. After 14 days, it's 1.65% on top of that if you don't pay within the 14 days. You have to? Can you just sit back and go, "No, I want to stay with my original"?
Absolutely. I mean, yeah, you could say, "Look, I'm happy with the old terms," and they might say, "Well, that's great, but we're not prepared to supply you anymore." Right. And usually the credit applications, there's a right to review the credit the credit limits. If it's just the case that, look, you just want to keep the 30-day term, but otherwise you'll accept their terms, then everything is negotiable. Yeah. And otherwise go to someone else. They would have the right to say, "Look, any future supplies are going to be on these terms going forward. If you don't like it, go somewhere else, or let's negotiate."
Question about the client. They're in the retail industry, so you don't normally get to that terms and conditions set out beforehand.
No.
What sort of led to that? Because I know they do set out their terms and conditions on invoices, you just set it up from there. For example, they'll be labelling and stuff like.
Yeah, that's an interesting question. So, in a retail context, your contracts are made at point of sale. So you've got offer acceptance, delivery, invoicing, it's all at the same times. It's more about incorporation from signage and things like that. Terms and conditions may or may not apply. Like if you go into a car park, for example, usually there might be a sign and it's on your ticket. And it usually says, you can leave in the next 10 minutes if you don't like these terms and conditions, if you actually park and decide to read them. But incorporation of terms in that retail context is really a requirement on signage within the shop or on the product. Well, that could absolutely. I mean, if I'm negotiating with you, so these are the terms we're prepared to say or sell. This product comes with this sort of warranty. Then that could be part of the contract, or it could be grounds for some sort of other action for misleading or deceptive conduct. Yeah, normally that's sort of reinforcing what was there. But particularly if you're trying to have something that might be a bit out of the ordinary, then you want signage, and quite clear signage within the shop. Any other questions?
there's another one that bookkeepers should put in their contracts, and that's confidentiality, because it sells the contract to the client. It makes it easier to get the client's signature if you say that the contract's sitting there and it's protecting your confidentiality, because really all our staff are under that confidentiality agreement. It's a good clause to put into a
It's a good point. I sort of take that for granted in our industry, but I guess when you're making those contracts in those circumstances, providing in writing that this is what you're assuring them, yeah, that's good. Right. Okay. Well, thanks very much, everyone.